I'm Meredith Muller, and today we are going to discuss UCC 2207 Battle of the Forms. A lot of students do not like this section of the UCC. They find it convoluted and confusing. And it can be, but that's why I am here with you today. We're going to walk through the elements of UCC 2207 Battle of the Forms so that you can understand how you can still have a contract even if the acceptance contains additional or different terms, as well as what happens to any additional or different terms that might be contained in an acceptance. So let's jump right in. First, I want you to know that at common law, we have the mirror image rule. Okay, you guys remember that from your readings, previous studies. At common law, an acceptance must mirror the offer. Okay, the terms of the acceptance have to mirror the terms of the offer. If they don't, then it's not an acceptance. It's a rejection and possibly a counteroffer. Okay, but under the UCC, meaning we're dealing with the sale of goods, an acceptance that contains different or additional terms can still be an acceptance. This is where we look to UCC 207 sub 1. And we ask ourselves, has a contract been formed by the communication of the parties? Okay, so in other words, we've got a battle of the forms going on. Okay, first form arguably is an offer, and it contains the contract provisions, a bunch of terms, and then I send you my purchase order. Okay, on my form that has a bunch of contract provisions and the contract terms that might be different, that might contain different or additional terms than the one that was on your original form. Okay, what I'm telling you is that under the UCC, okay, if we're dealing with the sale of goods, we can still have an acceptance even though it's not a mirror image of the offer. Okay, so your acceptance can still be valid, okay, and operate as an acceptance as long as we have a definite and seasonable expression of acceptance that is not expressly made conditional on the assent to the additional or different terms. Okay, so think about that. Let me break it down into the three elements there. So the first is that definite expression of acceptance. That definite expression of acceptance. What do I mean by that? Yep, I'm in. I want to buy that. Yep, let's do business. Okay, that is a definite expression of acceptance. Okay, you want to work with the offeror. You're accepting the offer. Okay, but your definite expression of acceptance, the I'm in, contains additional or different terms. Okay, so your form again might have additional or different terms in it. Okay, it also has to be seasonable. So a definite and seasonable expression of acceptance. What do I mean by seasonable? That just means it has to be communicated within a reasonable time. Okay, so yeah, let's do this, and then you go ahead and you send your purchase order. Okay, so a definite and seasonable expression of acceptance. Okay, so that's number 1 and 2. Okay, so as long as you have a definite and seasonable expression of acceptance, you have a contract formed by the communication of the parties, unless that acceptance is made expressly conditional on assent to the additional or different terms. Okay, so if your acceptance form says this form shall not operate as this writing shall not operate as an acceptance unless the offeror assents to the additional or different terms in this writing. If it says that, then there is no contract formed by the communication of the parties. So how do we get a contract? We have an acceptance that contains different or different terms, that is a definite and seasonable expression of acceptance that is not made expressly conditional on assent to the additional or different terms. Okay, so we still have a contract, but now we have to worry, what happens to those terms? We have different or additional terms in now. We got a contract, yay, but what are the terms? So that's where we look to UCC 207 sub 2. Okay, what happens to those additional terms? This question turns on merchant status. Okay, merchant status, where both parties are merchants. And merchants are those that hold themselves out to be knowledgeable in a particular good. They deal in those goods regularly. They deal in the sale of those goods. Those kinds of things. So merchant status matters here. So before we get into the meat of UCC 2207 sub 2, let me clear up something. A lot of students get confused thinking that the UCC only applies to merchants. I don't know why, but that happens sometimes, and it's untrue. The UCC applies to the sale of goods, all sales of goods, whether you're a merchant or not. Okay, so if I am Home Depot and I am dealing with a ladder manufacturer, we're both merchants. Okay, those are merchants, and the UCC applies. Okay, and then certain provisions of the UCC are going to apply to us as merchants. Okay, I could also be your next door neighbor, and I'm selling you a ladder. Okay, and we are not merchants, but the UCC still applies. Okay, so the UCC applies to all sales of goods, and certain provisions of the UCC apply to merchants. This happens to be one of them. Okay, because we treat merchants differently than we do non-merchants under UCC 2207 sub 2. So again, we're asking ourselves, what happens to the terms? We have a definite and seasonable expression of acceptance, okay, that is not expressly made conditional on assent to the additional terms. So therefore, we have a contract. Now what happens to the terms? If the parties are non-merchants, the additional terms are construed as proposals for additions to the contract. And they're not going to be part of the contract unless they are accepted by the other party. Okay, so non-merchants, the additional terms are not part of the contract unless the offeror assents to those additional terms. Okay, period. So this is additional terms, by the way, not different. We'll get to different in a minute. Okay, if we're dealing with merchants, then those terms, the additional terms, become part of the contract automatically, unless one of these three things happen. Okay? If the offer expressly limits acceptance to the terms of the offer, then those additional terms do not become part of the contract. Okay, so if your form says this offer is expressly limits its acceptance to the terms of the terms contained herein. If it says that, then any additional terms that you might put on your purchase order and send along as your acceptance are not going to become part of the contract, because the offer expressly limited acceptance to the terms of the offer. Makes sense. Easy breezy. Okay. The additional terms are going to become part of the contract automatically unless the additional terms materially alter the contract. Materially alter. So if it's a material alteration. Okay. Now these are things that they're going to jump out at you. Usually you're going to be able to tell if it's I have to pay for shipping. That's usually not a material alteration, okay? And the additional term, requiring you to pay, $50 for shipping, not a big alteration, especially if you're dealing with a couple $100 contract, okay? However, it could be a material alteration if it's something that you would not have accepted, okay? So arbitration clauses are often considered material alterations. Okay, because think about it, with an arbitration clause, you're agreeing to give up your legal right to enforce your contract rights in court. Okay, instead you're agreeing to go to alternative dispute resolution through arbitration. Okay, so an arbitration clause is a material alteration of the contract. So if your acceptance contains a arbitration clause, it might be construed as a material alteration, and therefore that arbitration clause does not become part of the contract. Okay? The third thing that will keep the additional term from becoming part of the contract is if the offeror objects to the additional term within a reasonable time. So I get your form and I say, oh, I see that this includes shipping charges. I'm not paying for that. All right? So that is an objection to the additional term within a reasonable time. So again, if you can still have a contract if the communications between the parties demonstrate a definite and seasonable expression of acceptance that is not made expressly conditional on on assent to the additional terms. Okay, and then those terms do not become part of the contract if you're dealing with non-merchants, unless they're accepted, and do become part of the contract automatically if you're dealing with merchants, unless one of those three things happens. The offeror expressly limits acceptance to the terms of the offer, the additional terms materially alter the contract, or if the offeror objects to the additional terms within a reasonable time. So here's a hint, guys. We like to test material alteration. Okay? And oftentimes, it's either going to be very clear, mostly in a multiple choice question. You'll be able to see it. It's an arbitration clause. It's something that you clearly would not have agreed to this contract if this was included. Okay? Or it's going to be debatable in an essay question, and you'll have to argue. Well, is this a material alteration or not? What is plaintiff going to argue? What is defendant going to argue? Okay, so we like to test material alteration. Okay, so that is additional terms. What about different terms? What about different terms? Okay, different term, what do I mean by that? It contradicts an existing term in the offer. Okay, a different term contradicts an existing term in the offer. So perhaps your contract says that the buyer will pay for shipping, and my contract says the seller will pay for shipping. That is different. That contradicts the term in the offer. Okay, so my term in my acceptance contradicts the term in my offer. Okay, well, what happens to that different term? Under the majority rule, we call this the knockout rule. Okay, we knock out that term from the contract. Okay, in other words, the terms just fall out of the contract, and we're going to replace them by an applicable UCC gap filler. It is not important to you to know what those gap fillers are. Okay, it is just enough for you to say that the conflicting terms are going to be knocked out and replaced by applicable UCC gap fillers. So the gap filler might say that seller is responsible for shipping. Okay, if so, then that's the term that becomes part of the contract. Okay, what is the UCC gap filler? Again, you don't need to know what the gap filler actually says. You just need to know that there are gap fillers in the UCC, and the conflicting terms will be knocked out and replaced by one. Okay, that's the knockout rule. That's the majority rule. Now, a minority of jurisdictions are going to treat the different terms the same as they do the additional terms. Okay, so we go back to our UCC 207 sub 2, and we ask ourselves, are we dealing with merchants or non-merchants? Okay, if the different term is in the contract and you're dealing with non-merchants, that different term is not going to be included in the contract, okay, unless it's accepted. So our offer is going to control there. If we're dealing with merchants, okay, then that different term needs to be analyzed to see if we've expressly limited acceptance to the terms of the offer, if it materially alters the contract, or the offeror objects to the additional term within a reasonable time. Okay, so we treat them just like additional terms, but the majority rule is we just knock them out. Okay, we knock out those different terms. So now that we've determined that we can have a contract even if the acceptance contains additional or different terms, what happens if no contract is formed by the communications of the parties? Okay, can we still establish a contract under the UCC if the perhaps we don't have a definite and seasonable expression of acceptance, or perhaps the acceptance is made expressly conditional on acceptance of the additional term? Okay, then no contract is formed by the communications of the parties under UCC 207 sub 1. So at that point, we have to look at UCC 2207 sub 3. Okay, sub 3 says even if the communications of the parties do not establish a contract, the conduct of the parties can. Okay, the conducts of the parties can. So look to see if the parties are actually performing under the contract. Okay, if they are, then the conduct of the parties show that we have a contract, we've established an existing contract, and the terms are going to be those that the parties agreed on. And then the UCC gap fillers will be used where needed. So if no communication, if no contract is formed by the communication, look to see if you can prove the existence of a contract by the conduct of the parties. All right. Now that we've gone through all of the rules, let's talk about how to pack it up in a nice, neat little bow, okay, and work through steps to see how we would approach this if we were confronted with it on an essay question, okay, or a multiple choice question. Okay, so the first thing that we do is we're going to ask ourselves two questions. Okay, what happens if an additional terms are included in acceptance of a contract with sale of goods? Two questions we're going to ask ourselves. Number one, is the potential acceptance a definite and seasonable expression of acceptance? And number two, is the potential acceptance expressly conditioned on agreement to the additional or different terms? So if you answer yes to question one, we have a definite and seasonable expression of acceptance, and no to question number two, it's not conditioned on agreement to the additional terms, then we have a contract formed by the communication of the parties. Okay? If you answer in any other combination, okay, no to one, no to two, no to one, yes to two, whatever it happens to be, any other combination, then no contract arises from the communication between the parties, and you need to look at UCC 207 sub 3 to see if the conduct evidences existence of the contract. Okay, so after we do this, we need to decide what happens to the terms. So we ask ourselves, if we've answered yes to question one and no to question two, and we have a contract formed by the communication of the parties, we have to ask ourselves, are both parties merchants? Either yes or no. Okay, if not, the additional terms do not become part of the contract unless the offeror assents. If they are both merchants, the additional or different terms become part of the contract unless the offeror expressly limits acceptance to the original terms, or the additional or different terms materially alter the contract, or the offeror objects within a reasonable time. So then if we have to go to UCC 2207 sub 3, and we need to look at the conduct of the parties, okay, if we answer in any different way to those first two questions, okay, a definite and seasonable expression of acceptance and expressly conditioned on agreement to additional terms, okay, if we do not answer yes and no, we answer in any other combination, then we have no contract arising from the communication of the parties. And then we look to the conduct of the parties. So if they're performing under that contract, then that's sufficient to indicate the existence of agreement. Okay, and the terms of the contract are going to be any terms upon which the communications agree, conflicting terms knocked out, and gaps are filled by gap fillers. Easy, easy, easy breezy. So let's wrap this up by checking ourselves. Okay, let's make sure that we know how to apply these rules. We've got Luke. Luke is a Georgia resident, and he buys and sells antique cars. Okay, Luke writes an offer letter to an antique car dealer in Florida. Okay, so we've got Luke that buys and sells antique cars, and we've got a car dealer in Florida. So we've got both parties are merchants. Okay, and Luke's offer letter says, I'd like to buy your 1969 Corvette that's listed on your website. I'll give you $30,000 for it. Please have it delivered to my address next week. Luke includes a signed check with his letter. The car dealer ships the car to Luke and includes a letter that includes a $500 invoice for shipping charges and an arbitration clause. And so our question is, has a contract been validly formed? And if so, what are its terms? All right, well, let's go through the whole process. All right, our additional term here is the $500 shipping charge and the arbitration clause. So let's take those separately. Okay. First, we have to determine whether or not the communications, if there's a definite and seasonable expression of acceptance. Okay. So the car dealer ships the car to Luke and includes a letter that includes a $500 invoice for shipping. So obviously the car dealer wants to deal with Luke. They ship the car to him. Okay, so that's a definite and seasonable expression of acceptance. Okay, I don't see any facts in here that say anything about the car dealer's acceptance being expressly conditioned on Luke's assent to that $500 charge or the arbitration clause. Okay, so since we answered yes to question number one, definite and seasonable expression of acceptance, and no to question two, not made expressly conditional on assent to the additional terms. Okay, we have a contract between Luke and this car dealer. Communication of the parties form a contract. Well, now what happens to those two additional terms? All right, well, let's see. Are both parties merchants? Yes. Luke sells antique cars, and our antique car dealer is a car dealer. So we've got both parties are merchants. So now we know that the additional terms will automatically become part of the contract unless we have one of those three things happening. Okay, so let's take one at a time. Let's take that $500 invoice for shipping first. Okay, so we're both merchants. So we know that these additional terms are going to become part of the contract unless the offer expressly limits acceptance to its original terms. I don't see any facts that say that. Or the additional or different terms materially alter the contract. Does a $500 shipping charge materially alter a contract for a $30,000 car? Probably not. Probably not. So we're going to say there's no material alteration there. Okay. Or the offeror objects to the additional terms within a reasonable time. There's no facts here that says that Luke objected to the shipping charge. Okay. If he does, then that won't become part of the contract. But we have none of these three things happening. So that $500 shipping charge becomes part of the contract because we're dealing with merchants. Now, what about that arbitration clause? Well, let's go through it again. Again, we have a definite and seasonable expression of acceptance. We don't have we have not made it expressly conditional upon assent to the arbitration clause. So we have a contract formed by the communications of the parties. We have to determine what happens to the terms. We know that we're dealing with merchants, so that we know that these terms automatically become part of the contract unless we have the offer expressly limiting acceptance to the terms. Again, no mention of that. Do they materially alter the contract? I said earlier that an arbitration clause is a pretty big deal. You're giving up your rights to go to court should you have to enforce your contractual rights. It's a pretty big deal. So arbitration clauses generally are considered to be material alterations. Okay, so unless if you bargain for them, it's a different thing. But if it's just a standard boilerplate language or something like that, that's a material alteration. All right, so we're going to say that arbitration clause is a material alteration, and it is not going to become part of the contract. Okay, and then again, we have no facts that suggest that Luke objected to the additional different term within a reasonable time. Okay, so the shipping charge is going to become part of the contract, but the arbitration clause is not. So that's how we work through a UCC 2207 problem, guys. Fun stuff, huh? So if you like this and like the way that we packed it up into a nice, neat little bow at the end and walked through it and talked about the various elements of UCC 2207, our book, Essential Elements, which you can order on Amazon, and it's got a partner site at passthefylse.com, has a bunch of materials, flowcharts that go through these types of elements, a lot of practice questions that you can check yourself on, and it might just help you go a little less crazy when you're dealing with some of these the more complicated issues. So I hope you enjoyed the mini lecture here. And the next time that you see a UCC 2207 sub 1, 2, or 3 problem, you'll do a great job on it. Thanks for listening, guys. Bye-bye.